Mr. Clay.
Thank you, Mr. Chairman, and thank you, Chairman Bernanke, for coming today. You have stated...
Would the gentleman speak directly into that microphone? Thank you.
You have stated that the Fed acted appropriately regarding issues of public disclosure. You have further stated that neither you nor any member of the Federal Reserve ever directed, instructed, or advised Bank of America to withhold from public disclosure any information relating to Merrill Lynch, including the losses, the compensation packages or bonuses. And I can believe that, and I have found you to be a person of integrity and of the highest degree. Retrospectively, looking at the developments that occurred with the whole saga of B of A, Merrill Lynch, and the Department of Treasury, and looking at the losses investors, both institutional and individuals, absorbed, do you feel that you had some responsibility to disclose some of this information that you knew was being withheld?
No, the information about the losses was the responsibility of Bank of America to disclose, and it was up to them with their counsel to determine when that was appropriate. We, the government, were required to disclose the terms of the deal within a week after it was consummated, and we did that.
At what point does the welfare of the investor become as important as the institution invested in?
The welfare of the investor is very important, and my concern was that the system would collapse, that Bank of America would collapse, which would hardly be a good thing for the investors.
And that was your responsibility then?
My responsibility is to protect the overall financial system, but I have to do that within the boundaries of supervisory practice and law. And
at what point should you disclose information to the public?
With respect to this particular issue, the law is clear that any action regarding TARP needs to be disclosed within a week, and we did that.
Do you believe that the people were better served by being uninformed in making their investment decisions, especially when official America knew there were misrepresentations in the financial status of B of A?
Well, again, those judgments were up to Bank of America. Our job was to try and make sure that the system was stabilized, and that was our primary focus.
Mr. Chairman, why did you think it was necessary for B of A to acquire Merrill Lynch when Lehman had been allowed to fail? What was the thinking of saving AIG, Merrill, and Citigroup when these companies had failed to adequately perform and uphold their fiduciary responsibilities to its stockholders? What made these three different from Lehman?
We made extraordinary efforts to prevent Lehman from failing. We were unsuccessful, partly because we couldn't find a merger partner. Bank of America was a potential merger partner. They decided against it, and we didn't try to coerce them to do it. We didn't have the powers to save Lehman, and that's why they failed very much. You know, we were very concerned about it, and our concerns proved to be justified. With respect to the other cases, we did everything we could to avoid a systemic failure because of the risk to the financial system. AIG, as I mentioned earlier, was possible to address because the large insurance company provided collateral for a loan that would allow us to provide liquidity to the financial products division, which was the source of the problem. After the Congress passed the TARP legislation, it was then much more direct and easy to address these problems. If we'd had the TARP money in September, we might have been able to address the Lehman problem.
Was it really necessary to salvage AIG? I mean, I heard your explanation, but
I do believe so.
They failed. They failed their own investors. They failed themselves.
I had no sympathy for AIG, and particularly for the financial products division, but my concern was that if they failed, that the consequences would have been a worldwide banking run, a severe financial meltdown, and very unknown but difficult consequences for the global economy, and I didn't feel that I could take that chance.
And I guess we thought the same about American automakers a few months ago. that they just couldn't fail either, and they couldn't go into bankruptcy, but we know a different story. Now, thank you, Mr. Chairman, for your responses. Mr. Chairman, I yield back.
I thank the gentleman. The chair recognizes Mr. Fortenberry. You may proceed, sir.
Thank you, Mr. Chairman. And thank you, Chairman Bernanke, for your appearance here today. I read your testimony, and it appears to me to be a reasonable explanation of your role in the Bank of America Merrill Lynch merger and the advocacy of certain additional bailout funds. However, while that's the narrow purpose of this hearing, to unpack whether or not there were any conflicts there, and certainly you can understand the cynicism in that we've got conflicting impressions from you and Mr. Lewis about the nature of this deal. I think fundamentally what is at issue here, what is the heart of the matter, is the Fed's future role as a systemic regulator. And in that regard, let me go back to a couple of points that were just touched on. Do you believe it was in the best interest of this country for Merrill Lynch and Bank of America to be merged and to receive the bailout funds that they received? First the $25 billion between the two companies, and then later the $20 billion as Bank of America expressed concern, or let's put it another way, waffling about the potential deal.
I think it was critical that we avoided the failure of those firms and the implications that would have had for our financial system. We did so in a way that protected the taxpayer, and again, I think we did the right thing.
One thing that concerns me about this, though, is information that we have from the FDIC Chairman Sheila Bair, who wrote to you prior to the final bailout monies being received by Bank of America. She said, "Dear Ben, strong discomfort with this deal at the FDIC for all of the reasons you and I have discussed." What did you discuss?
My recollection is that her concern was not about taking action to stabilize Bank of America. Her concern was that the FDIC would have financial exposure as part of the transaction. And she was concerned in particular because the transaction involved not only a bank but also an investment bank, which was not in her sphere of responsibility. So it was that the details of the transaction, I understand it, that were her concern, not the basic idea of taking steps to stabilize the company.
Currently, we have a situation, it's my understanding, where 10 major banks control about 50% of deposited assets in this country, Bank of America being the largest. Is this a systemic risk?
We have large banks, and under our current system, and particularly under current circumstances with financial conditions the way they are, the failure of one of those firms would be very dangerous for the American economy. And that's why I believe that the centerpiece of financial regulatory reform should be steps to get rid of too big to fail, to find measures that allow a large firm to fail when it's appropriate, but to do so in a way that doesn't bring everything else down with it.
Well, I agree with that assessment, but I think it's pointing to the need to, in whatever future regulatory framework that we have, to consider the fact that we have 10 banks controlling a majority of assets in this country, and that systemic risk is very real. Do you agree with that?
It's certainly real now, but I think there are steps that could reduce the risk associated with those banks.
What will be those steps, potentially?
Well, for example, greater oversight, capital, and supervision of those companies, a resolution regime that would...
that assumes failure.
In the case of failure, that's correct, but that would create more market discipline because lenders to those banks would know that they wouldn't necessarily be made whole in the case of a failure, and they would therefore exert more discipline on those companies.
The point I'm driving at, are these too big? These banks too big?
I think it's important that banks have no incentive to grow just to become too big to fail. But large banks probably have some other economic purposes, including global transactions networks and the like. I doubt we can go back to the world with only very small banks.
But we are concerned that this level of concentration in the hands of too few is a potential systemic
It's a legitimate
problem.
concern, Congressman, absolutely.
All right. I'd like to, Mr. Chairman, I'd like to yield the remainder of my time to Mr. Burton from Indiana.
The gentleman has the remainder of the time, which is about a minute.
Well, thank you very much. You indicated that Secretary Paulson's comment that that he made that threat at the request of Chairman Bernanke was changed later on by Mr. Paulson. So what he said was, and I think this ought to be in the record, his prediction of what could happen, talking about you, his prediction of what could happen to Lewis and the board was his language, was Paulson's language, but based on what he knew to be the Fed's strong opposition to Bank of America attempting to renounce the deal. You were the Fed. And he said it was based upon the knowledge that, that the Fed's strong opposition to Bank of America attempting to renounce the deal was something that he knew to be the case, and that he was, in effect, speaking on behalf of what you had said to him.
The gentleman's time's expired. Chairman Bernanke, you're directed to answer his question now. Thank you.
We were strongly opposed to that action for the reasons I've described.
Is that your answer?
Yes.
Okay. I thank the gentleman. The chair now recognizes Mr. Welch. Thank you.
Thank you, Mr. Chairman. Mr. Bernanke, I have one comment and two questions. My comment is thank you for your incredible service in very turbulent times. You've been very steady, and I think all of us really appreciate that. Two questions, one about Mr. Lewis and Bank of America, and then one following up on what Mr. Fortenberry was asking about. Mr. Lewis was here, and he had a number of different stories on a single transaction. He told the shareholders that this Merrill deal was a great deal for them, and persisted in that story even in December after he found out about a $9 billion additional deterioration. And to frankly, my amazement and shock, he never bothered to tell the shareholders the news that led him to the next assertion he made, that was so dire that he might invoke the nuclear option of the MAC clause. And then he told us, basically, that using his words, he didn't use the word threat, but he said there was heavy pressure from the Fed and Treasury to go through with this deal, with the assurance that the American taxpayer, through the Fed and the Treasury, would back up any of the toxic assets from Merrill. And I'll just ask one specific question about that. One of his assertions to the board was that the Treasury and Fed have confirmed they will provide assistance to the corporation to restore capital and protect the corporation against the adverse impact of the Merrill Lynch assets. And he went on to say the corporation can rely on the Fed and Treasury to complete and deliver the promised support by January 20, the date scheduled for the release of earnings by the corporation. In your recollection, is that an accurate statement by Mr. Lewis?
We did indicate that we would work with him in good faith to develop a transaction, develop a package that would preserve the stability of his company, and we proposed to do that by January 20th.
And that included backing up the toxic assets on Merrill's balance sheet?
There were no specifics about how we were going to do it. There were different possible approaches in the event that ring fence is apparently not even going to be consummated.
All right, but what he was specifically referring to was the news that they were aware of, that Merrill had far more in toxic assets than had been disclosed to shareholders when they approved the deal in the early part of December. So is it your recollection that the assurance he gave his board that the Fed and Treasury would back up the toxic assets on Merrill was accurate?
Well, he knew that in the case of Citi, for example, that we had used both capital and a ring fence. So clearly that was one of the options that we were discussing as part of the transaction.
Okay, I want to get to this question that was started by Mr. Fortenberry. You've wisely stated, in my view, that we do need a new regulatory regime to protect the economy from systemic risk. And there's really two approaches that can be taken, and the Congress has to make a judgment which is the better one to go. One is a supersized regulator or some entity that has the capacity to monitor the risk of these huge financial conglomerates that when they go down bring us all with them. That's one approach. The other approach is to take the view that if an institution is too big to fail, it's too big to exist. And the virtue of that, frankly, is that it brings them down to a size where we don't have to depend on the vigilance of regulators being overcome by the influence of the financial industry. So my question to you is, does it make sense for Congress to pursue a policy that says if an institution is too big to fail without threat to the economy, it is in fact too big to exist, and instead of regulating it, we should break it up?
Well, there are two options. One is to allow large banks, but to take steps that will protect the economy if in fact one comes to the brink of failure, which is what the Treasury's proposal, for example, includes. The other possibility is to restrict the size of banks. I think it's legitimate to discuss both options. I would just point out that very large banks do have an economic function, a global reach, diversity of activities, but Congress may wish to look at different options. I don't want to prejudge what you will be deliberating.
Okay, thank you. I yield back.
The gentleman yields back. When our colleagues on the Republican side have others who show up, they'll be recognized in a turn. We recognize Mr. Kanjorski.
Mr. Chairman, thank you for your testimony. And I've listened to a lot of my colleagues today use words like threats, even lies, lying. The reality is, if a judge cautions an attorney that certain conduct would constitute contempt, it's not a threat, is it? That's telling them the power of the court. It's laying out what the rules are. I can't see how people are jumping to the conclusion that by either yourself or the Secretary of Treasury informing a bank officer or a board that there were powers of the government to take action of a certain way which could constitute removal of the CEO or the board. That doesn't constitute a threat. That's informing them of what the powers are, isn't it?
As long as the reason for exerting that power is legitimate, i.e. that the manager took actions that prejudiced his own company.
And then that would be an issue that later on could be determined. But
That's
nevertheless, It's not a threat. It's telling them the truth. This is what,
Yes, sir.
These are the confines of the power we have, and we're willing to use it. I'm glad somebody told them that, if they did. I don't know they did, because I doubt whether they seriously did. I listened to Mr. Lewis both here and as a witness, and I interviewed him individually, and he's sort of rather happy with the acquisition that he made, and it accounted for 75% of its profits of the Bank of America in the last quarter. So I would suspect that about 6 months to a year from now, he's going to be touting this tremendous victory of his of acquiring Merrill Lynch. But all that being said, what we really, I don't know why we're spending our time to find out what happened between the 15th of September and January 1st. All we all know is a hell of a lot went over the dam, and particularly in that spectacular 2-week period after September 15th. I want you, one, before you leave here, to tell this committee and the American people what kind of jeopardy the American system and the world system was in, so we reiterate that moment, that we weren't all a bunch of relaxed, confident people walking around making clear judgments, but we were making emergency judgments, working 20 and 24 hours a day, and not with the clearest heads in the world. Is that correct?
Thank you, sir, for that opportunity. September was an incredibly intense period of financial crisis. Many of the largest firms in America came under very severe pressure. The failure of Lehman Brothers and the near failure of AIG were important reasons why the world economy went into a nosedive that lasted for the entire fourth quarter of 2008 and the first quarter of 2009. The Treasury, the Federal Reserve, and other agencies worked overtime to try to prevent additional failures, additional crisis. Fortunately, the Congress provided the TARP funding in early October. In mid-October, there was an incipient global banking crisis that involved responses by policymakers around the world, the UK, Australia, Japan, Germany, and elsewhere. The United States was able to join in that effort because of the TARP money. We averted at that time a global financial meltdown, which in my opinion very likely would have created a depression-like environment in the United States, far more severe than the recession we've seen recently.
Thank you very much, Mr. Chairman. And I gave you your shot. Now I'm going to come back at you. Okay.
Sure.
The thing we have to decide is what we're going to do in the future and how we're going to handle it. And one of the things in the last several months that I've been involved in investigations of everything from the Madoff case to other transactions in the market. But studying the inside of our regulatory authorities, I find that although they may have the authority, they may have the money to act, they sometimes don't know how to act or don't act properly. And as a result, they have all the authority in the world to prevent something from happening, but it happens anyway. And I want to say that charge would lie against the Federal Reserve. And that's where we're hung up in the course of a dilemma. The Federal Reserve, as I can see it, had several opportunities to prevent this economic crisis. One is the long-used 14 years of power to lay down the conditions on mortgage obligations in this country, that all the way through about 12 of those 14 years, the Federal Reserve failed to take any action until you came on the scene and finally did enact a set of standards across the board. If they had enacted earlier those standards, most of these toxic assets we talk about wouldn't be circulating around the world with the imprimatur that they're supported and passed on by the United States government. Two, there are issues with the Federal Reserve that they are now acquiring additional powers when they have failed to use their past powers. Could you address those two issues?
Certainly, and I agree with you that
The gentleman's time's expired, but please answer the question.
Congressman Kondrasky, you're right that the Federal Reserve was late to invoke those consumer protection powers. We have been very aggressive, as you know, for the past couple of years. I think it's very important, if the Fed retains those powers, that we strengthen the priority that those have in our decision-making, and that we have strengthened accountability, that we report frequently to Congress about what we're doing on these areas. So that's very important. In terms of additional powers, I think it's worthwhile pointing out that if we look, for example, at the Treasury's proposal to make the Fed the consolidated supervisor of systemically critical firms, that is not a major difference in terms of powers from what we currently have, which is being umbrella supervisor of all the financial holding companies. Rather, it would be not so much a change in powers, but a change in approach, whereby we would take a system-wide approach in how we would regulate those firms, rather than looking at them bank by bank or firm by firm. So it's not a massive increase in powers, it's really a change in our strategy.
I thank the gentleman for his response. The chair recognizes Mr. Turner.
Thank you, Mr. Chairman. Chair Bernanke, I want to thank you for being here today. I know that we have had very difficult times, and certainly you and Mr. Paulson and others we know have worked diligently to try to restore the financial security of the country. There are divergent opinions, though, of the actions that are taken and how we should approach them. I have voted against every bailout that has come before this Congress. And I've done that because I felt that the programs that were put before us were not clearly defined. The scope of the cost or expense was not clearly defined. The ability to hold people accountable was difficult to ascertain in programs that were undefined. And I think that we're seeing now, as the American public looks at this, there's a lot of unintended consequences. There are things that are happening that the American people are saying, well, I didn't quite think that that's what it's going to be. I know you're facing a lot of questions today concerning Bank of America and Merrill Lynch, and they go right to the heart, I think, of questions concerning the federal government's proper role in private enterprise. How do we step in appropriately? How do we not step in? You know, the federal government has very mixed performance when it comes to the issues of interfering or intervention in private enterprise. Frequently, this committee has hearings on issues as basic as our contracting processes with private enterprise. We're not a very good customer. Many times issues arise where people wonder whether there's been abuse of processes, conflicts of interest. So when you then put another layer of us just not being a customer, but us being an investor, an entity that's providing a bailout, or even an owner, people have a great deal of concern. Yesterday, I introduced House Joint Resolution 57, the Preserving Capitalism in America Amendment. It is a proposed amendment to the United States Constitution. It came about as a result of my discussion with people back home, because several people that I spoke to said that they did not believe that enough people were taking a stand to say, this is wrong. I don't believe that this should have happened in this manner. I know we have difficulty, but I don't agree with this structure. I don't agree that we should own General Motors. The constitutional amendment would limit the ability of the federal government to acquire an ownership interest in a private corporation. It does give the government the ability to issue loans, It also allows us to invest in public authorities, public use corporations, and also allows investments by government pension funds. It turns out that as I was discussing this with people in my community, that limiting government ownership over private enterprise is not a new idea. We found that at least 8 state constitutions have in some form limited the state's ability to acquire stock or equity in a company, apparently as a result of the Panic of 1837, which you would know a whole lot more about than I do, as a result of your great historical expertise. But a number of people have concerns as the Obama administration moves forward, as the bailouts in the financial sector move forward, as our domestic automobile industry becomes publicly owned. The constitutional amendment that I dropped yesterday was dropped with 102 original co-sponsors. Nearly a quarter of the House stepped forward and said, I want to support a constitutional amendment because we don't think it can be done by statute, that could say, we understand that there are times when action needs to be taken. We understand when intervention needs to occur. But we do not believe that ownership is a structure that should be an available option. We're very concerned about what happens next. For example, we have a huge ownership interest in General Motors. We don't in Ford. Let's say both of them bid on a government contract. What happens then? Can Ford be assured that they're going to have the equal treatment when the government's virtually bidding for its own contract? I'd like your thoughts on the amendment, and if that amendment was in place, I'd like your thoughts as to how you would have gone about and how TARP funds would have been used and some of these other things could have been structured in a way where we wouldn't have ended up with ownership, but you would have responded to our financial crisis.
Well, excuse me, I agree with you that limited government ownership, limited government intervention in the private sector is frequently a good policy, and in that respect, I think that's a very good approach. I should say, though, that in order to make that a viable policy in our financial sector, we need to have a set of rules and regulations that can allow financial firms to fail, and I believe in failure. Failure. Capitalism without failure is like religion without sin, somebody said. You need to have failure, but you have to have failure in a way that's not going to bring down the entire system. So if you're going to do that, you need to also have rules and regulations that allow the orderly wind down, the orderly failure of large financial firms.
Before we conclude, Mr. Chairman, if you'd allow me. So I don't believe you're saying, are you, that you think that the only way you could have intervened is to result in ownership, that there weren't structures of loans and other assistance that could have been provided that wouldn't have ended up in the federal government having an ownership interest, and then, of course, therefore, where we get this conflict of well, how is the government going to execute its ownership interest?
I'd have to think about that, but if you look at banking crises in history, Japan and Sweden and the U.S. in the 30s and so on, frequently you do have a period of capital being injected by the government, which essentially is a temporary ownership. Usually those things are only temporary, but again, I'm not sure what the alternative would be. I'd be happy to think about it, but in order to avoid ever having government ownership, again, you need to figure out a way to avoid having the crisis in the first place, and I think that should be the first priority.
Well, I appreciate your thoughts, because people are obviously very concerned about this, and this looks like a line that perhaps we should not be. Thank you so much.
Thank you very much. Yield to the gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman, and thank you, Mr. Chairman. I just, as someone voted against the TARP, I just want to comment on your kind remarks in saying that through the wisdom of Congress, we passed the TARP bill. Number one, as you may remember, TARP was presented to us as a way to purchase toxic mortgages. It was never used for that. So what we voted for was never put into action. Number two, several weeks after we did the TARP bill, we also passed a TARP corrections bill. It was a 400-page bill that we passed to correct all the mistakes that we made in TARP. So I'm not so sure that the wisdom of Congress is necessarily accurately ascribed in that statement. I do want to say I agree with Chairman Kanjorski about the context in which you took all this action. The sky was falling. It was a very difficult time. But I do want to say the reason we're going over this chronology is because we have granted the Fed enormous independence, and there is sometimes a tension between the primacy of the taxpayer's interest and the power of the Fed and the independence of the Fed. And that's why we're going over this. There's been a lot of back and forth today, but basically what the facts are is that Merrill got into trouble very early in 07 when E. Stanley O'Neill was there. It was a very difficult situation. There was a merger proposal that you supported quite strongly between Bank of America and Merrill Lynch. There was an agreement to enter into that merger, and then at some subsequent time were major losses. There were early losses, $8.4 billion that occurred in 07. It looked like an additional $12 billion that was discovered by Mr. Lewis on December 14, 2008, and then he announced his desire or his intention to invoke the MAC. And then we have a difference of opinion, and that is, on one side, some folks are saying that you or Mr. Paulson threatened Mr. Lewis. Other people say it was simply iron-fisted encouragement to have him stay in the deal. In any event, he did that. He stayed in the deal. And there's an interesting email from you, and I just want to go over this because I'm interested in the taxpayer's position. It says here, this is from you, Mr. Chairman, to Scott Alvarez. And it says, I had a good conversation with Lewis just now. He confirms his willingness to drop the MAC, the opposition to the deal going forward, and to work with the government to develop whatever support package might be needed for earnings announcements dates around January 20th. We discussed his common equity issue. We agreed that having a significant amount of TARP capital in the form of common equity was not an ideal solution given the ownership implications, but we agreed both to think about possible solutions, parenthesis, a government backstop of a capital raise, or government common with limited control rights. Now, it sounds to me like Ken Lewis is concerned about his job, and for the American taxpayer to get voting rights in return for their TARP money, Mr. Lewis would be gone, I believe. Is that the concern that you believe Mr. Lewis expressed regarding the TARP being presented with rights, voting rights for the American taxpayer in that deal?
I don't know exactly what his concern was. It may have also been involved in just concern about government intervention in his management and in the operations of the company.
Well, there was this discussion. It is what it is. It indicates that Mr. Lewis is concerned about the taxpayer having some input here, some control. And it sounds like it says, but we agree to think about possible solutions to that, a backstop of capital raise or government taxpayer involvement here with limited control rights. And I'm just wondering whether in this deal, to provide this support, whether the taxpayer is getting the full leverage that they should have gotten given the amount of assistance we put into this company, into this deal.
Well, the company is subject both to the restrictions of the TARP and the Treasury's provisions on executive compensation and the like, and they're also subject to, as has been discussed, they're subject to the supervisory oversight of the Federal Reserve and the OCC, and we have taken actions, for example, to ask them to add independent directors to their board and make other appropriate changes to their company.
Could we have not gotten greater protections for the American taxpayer in this deal than what we did in terms of considering that we're saving this company with the American taxpayer's assistance, and we don't gain the control that I think is commensurate with that support?
Well, I'm not quite sure. I'd have to go back and look at that email again. At that time, the TARP money was all provided in the form of preferred stock, which is, on the one hand, is not voting, but on the other hand is senior to common equity and therefore is safer.
They get paid first, I understand that, but it's the lack of, it seems like Mr. Lewis was most concerned with lack of input or lack of control on the part of the taxpayer, and I think that would have helped us,
in this deal if we had had greater control on behalf of the American taxpayer. Mr. Chairman, my time has expired. Again, Mr. Chairman, I thank you for appearing and helping us with our work. I yield back.
Thank you very much. I now yield 5 minutes to the gentleman from Massachusetts, Mr. Turney.
Thank you, Mr. Chairman. Mr. Bernanke, I want to discuss, if I can, for a second, it's just another way that public money seemed to have flowed to some of these financial institutions. Back in March of 2009, AIG disclosed the name of certain of the counterparties, people that they had credit default swap agreements with, and Bank of America was among them as well as others. It appears from our records here that there were losses in the so-called super senior multi-sector credit default swaps, the portfolio that AIG had, and that it created a liquidity problem. They had obligations that if there were problems in that portfolio, they had to put more cash in or more collateral security for their obligation. The Federal Reserve Board of New York then provided $85 billion in a loan to AIG. The testimony here was that then that money was used to buy out the contracts and cancel them. That's how they took care of that obligation. What was of concern to me and some others was that the counterparties appeared to have received 100% of that, even though testimony from people at AIG before this committee said that they thought that there were a lot of contentious reasons to think that they did not owe 100% if they owed anything at all on those particular obligations, that there had been serious negotiations about whether they should pay anything to these counterparties, and then if they should pay something, how much less than 100% they should pay. When we pressed Mr. Liddy, AIG, for background on that, for just how the negotiations went, why it is they paid 100%, his comment was that he was the wrong person to talk to, that in fact the Fed had all of those documents and paperwork because they in fact struck the deal. So my question to you is, why was 100% paid on these various obligations, including the one to Bank of America, and what was the rationale there? Why weren't the interests of the public money interests protected so that there was a better negotiation than just forking over 100%?
So I don't see on what basis that less than 100% could have been paid. They were contractual obligations. Failure to pay them would have allowed the creditors to force bankruptcy, which is exactly what we were trying to avoid. This is precisely why we need a resolution regime which would allow the resolver to haircut creditors and to abrogate existing contracts. But under current law, you can't avoid bankruptcy without paying off the existing contracts.
Well, except that the people that were running AIG said that they thought that there were certainly issues involved in that they didn't owe the money under the contracts, that default may not have occurred, or if it had occurred, it didn't obligate them to pay a full amount. These are people that were running the company, that had made the contracts, that felt very strongly. They've been negotiating on these for a period of time and apparently thought that they could have struck deals that would have not obligated 100%. These are contractual issues. So, you know, it could have been done. And yet, once they turned that matter over to the Fed and their inferences were, they just rolled over and gave 100% to Bank of America, Citibank, other people, and it looks to others from the outside that we were trying to make those people healthy, unquestionably, by taking public money and putting it in their coffers by folding on that deal. So my question to you is, will you produce to this committee copies of all the credit derivative contracts that AIG Financial Products Corporation had with those third-party counterparties, including all the details of the terms and conditions of the contracts, all documents and correspondence regarding the creation of Maiden Lane 3, the special purpose vehicle that was created by the Fed to do these transactions, and including the negotiations that went on for that, and then all documents and correspondence concerning the management and oversight of Maiden Lane Trust, so that we can get a look at those documents and make an assessment on that.
I think we've just, in our recent release, I think we just released a whole set of documents related to those issues. But if you have specific, we just created a monthly publication that provides a lot of information about the Maiden Lanes, for example. If you would send us a letter with specific requests, we'll see what's available.
We certainly will. Well, when you say you see what's available, I mean, we want everything that's available. And the question to you is, when we make that request, will you provide it?
If I'm able to do so, I will.
Thank you. Yield back, Mr. Chairman.
Very much. I now yield to the gentleman from Illinois, Mr. Davis.
Thank you very much, Mr. Chairman. And Chairman Bernanke, thank you for being here and your long patience and endurance. Let me just ask you, how involved is the Fed in the day-to-day management of Bank of America? For example, Does the Fed have veto power on major decision-making at Bank of America? And has any consideration been given to replacing upper-level management?
The Fed is not involved in day-to-day management. That's the responsibility of the board and the management. We are involved in evaluating the capital, the assets, liquidity, and the management of the corporation. We have had concerns about aspects of the management, and we have asked the board in particular to add independent directors, which they are in the process of doing, and we'll continue to be very careful and monitor the management situation. But we do not take daily decisions. That's not our job.
Mr. Chairman, let me ask you, when the government invested heavily in AIG, Fannie Mae and Freddie Mac, management was actually replaced. Why was the fate of Mr. Lewis so different in this instance?
Well, I think in this case that the merger was undertaken in good faith. It was at the time looked like a reasonable combination. A lot of firms suffered severe losses in the fourth quarter. It was one of the worst quarters, I think, in history in terms of financial losses. Our judgment at the time was that he could continue to lead the company, and we have not addressed that. But obviously we'll continue to evaluate management and the board as we go forward and make sure that we're comfortable with the leadership of Bank of America.
In an email from Mr. Wash to yourself on December the 30th, Mr. Wash writes, and I quote, "Ken Lewis is going to call you to reaffirm the understanding you have. Ken may also raise his favorite perennial issue, that is the Richmond supervisory team on same page as the board. Richmond staff was on our call today, but prior to the call, it sounds like they may have threatened a little more than ideal our need to get rid of dividend and fast. I told Price System will be making joint determinations. My question is, to your knowledge, do you think that Mr. Lewis's interaction with the supervisory team at the Richmond Fed threatened, coerced in any way, Mr. Lewis?"
Well, the Federal Reserve in general throughout last year was concerned about Bank of America's capital, particularly its tangible common equity. And the Federal Reserve Bank of Richmond, which was the supervisor of Bank of America, was interested in having Bank of America increase their capital, perhaps by reducing their dividend or through other measures. At various points, there were some confusions, I think, about what the position of the Fed was, because there were miscommunications between the Richmond Fed and the Board of Governors in Washington. And Mr. Lewis, far from being intimidated, was free to call me and ask me for resolution of these issues, and we made sure that everybody was on the same page and got that cleared up.
So it would be a normal interaction in terms of...
Yes, a normal process.
saying, look,
yes.
I'm having some concerns with Richmond and
Yes.
that kind of thing. Mr. Chairman, let me ask you, you've gone on record as supporting increased transparency in connection with Federal Reserve Board operations, yet the bailout of Bank of America was done behind closed doors without investor public knowledge or input. Could the American people really understand in any way what happened? I mean, what really happened? Was Mr. Lewis bullied into going forward with his own bad deal? Or did Mr. Lewis recklessly agree to pay too much for Merrill Lynch so that the federal government felt backed into a corner when faced with the prospect of Lewis backing out of the Merrill deal? And of course, we experienced the inevitable bankruptcy of Merrill Lynch. Could you respond to those?
Yes, sir. Today, I think, has been very productive in terms of transparency and more information about what happened. Clearly, there was a very difficult period and many complex problems that were being addressed, but as I've indicated, I believe that we solved this problem without in any way taking steps that were either beyond the law or unethical. And I believe we did the right thing in order to stabilize both companies and the financial system.
Gentleman's
Thank
time.
you very much, and thank you, Mr. Chairman.
Right, gentleman's time has expired. Yeah. Congresswoman Norton, for 5 minutes.
Thank you, Mr. Chairman, and we do appreciate the transparency you're trying to bring to this transaction. I am not inclined to second guess the judgment of people in the midst of trying to deal with the problem rising, problem after problem, in the midst of a crisis, an unusual crisis at that. I am interested in Bank of America's options under the circumstances. Bank of America had shareholders. We did have a series of rather unusual, late developing facts or factors to come to light in the process of the negotiations for this agreement. I'm wondering if it would not be true that let me lay the predicate for this by saying you apparently, the legal division apparently had an opinion that no Delaware court had been found that, I'm quoting now, that have found a MAC or material adverse effect to have occurred in the context of a merger agreement. Well, one would have to know the facts surrounding those circumstances and to suppose that they could not possibly have been at the same level of intensity as these, because we're in the middle of a national economic crisis. That aside, I can understand from that one sentence that without knowing what the case law was, that there was that conclusion. But could not Bank of America have negotiated a reduction in price with Merrill had it invoked the MAC clause? Wouldn't you think that would be the logical thing to try to do, given the obligation to the shareholders?
First, we did review the case law, and I think it was quite applicable. I'm not a lawyer, but the advice I got was that it bore very directly on the situation that we were looking at, specifically that short-term losses, no matter how large, are not basis for a MAC in this particular case. Only long-term, durationally significant losses in revenue or revenue production are grounds. And of course, Merrill Lynch has proved to be a profitable acquisition for Bank of America. Why not negotiate a better price? That wasn't the issue that Lewis originally raised. He was talking about just breaking off the merger. But I think that would also have been very dangerous, because the markets would have been faced with the uncertainty of whether or not the deal was going to go through. Merrill Lynch would probably not be able to survive absent the support of Bank of America, and so there would have been an immediate problem with Merrill Lynch, which would have created broader problems in the financial markets. I don't think
even if they threatened to do that in the context of negotiating.
Well, you can't negotiate anything unless you're willing to go through with your threat.
Oh,
as you
that
know.
happens every day, Mr. Chairman.
So therefore, there would have to be a probability in the mind of market participants that, in fact, Bank of America would not go through with the merger.
So you think that would have been considered a bluff?
I think that would have been destabilizing as well, yes.
In consummating, though, the merger, as it was originally planned, in effect, didn't the Bank of America shareholders take a good part of the hit of the Merrill losses?
Not in our view. As I said, when I talked to Mr. Lewis about this, I stressed that not only was invoking the MAC bad for the financial system broadly, but I thought our opinion was that it would be bad for the Bank of America itself, and in particular, if the invoking the MAC had caused Bank of America either to fail or to have to be saved at some emergency basis by the government, that clearly would not have been good for the shareholders of Bank of America. Now, of course, in the end, he had to make the judgment of what to do, but that, in my opinion, it was not obvious at all that invoking the MAC was a good thing for the Bank of America shareholders.
And you think he made that decision on his own without undue influence from the government in any way?
I believe he did.
Thank you, Mr. Chairman.
Thank you very much. Mr. Chairman, I know we have an agreement that we would finish at 1. Would it be possible for you to stay to 1:10? Would that create a problem for you? And I understand agreement.
Okay.
Yeah. Okay?
Yes.
Thank you. Thank you very much. All right. Well, let me just say to the members, what we would do is divide 10 minutes on each side. And, of course, at this point, so why don't we yield 5 minutes to the chairman, the ranking member on the committee.
Thank you, Mr. Chairman. I'll be brief. I just want to go through a couple of quick questions. First of all, it appears as though much of the media thinks the end justifies the means, meaning that even if there were threats or if people felt threatened to go through with deals, it's okay because it worked out. Do you agree with that?
No, sir. We used only legal and ethical means.
Okay, I appreciate that. Because do you also agree that at all times the rule of law and that the expectations that are written into both the letter and the broader meaning of the law should be the guidance for all transactions done behind closed doors by federal officials?
Yes, sir.
As we choose to find ways to resolve the ambiguity between Ken Lewis, Hank Paulson, yourself, and of course a number of people whose emails have been cited today, are you prepared to answer in writing, not a return here probably, additional questions that may come up that would help us clear that up?
Yes.
Do you at this time believe that intentionally Ken Lewis, Hank Paulson, or any of the people that we've cited today in emails intended to lie in their statements?
I have no judgment on that.
But you believe in good faith that they think what they're saying is true, at least as far as you know?
As far as I know.
Do you think that federal regulators should pick winners and losers as they go through trying to figure out in a crisis like this who gets to own who or who gets bailout money and who doesn't?
I think all these interventions are very unfortunate, and they're only made necessary by the extreme circumstances.
Earlier, one of the people we mentioned was Mr. Lacker. In light of his email paraphrasing a longer discussion, do you intend to speak to him and try to clarify how the difference in interpretation could have happened?
I've done so already, and he didn't have any further recollection.
Okay, and then I'd like to yield to Mr. Burton the balance of this 5 minutes.
Let me just say that I don't want to dwell on this, but one of the biggest problems I have is the government telling the private sector what to do and how to do it. We had the head of General Motors literally fired by the government. Now, maybe there might have been justification for his removal, but I didn't think the government ought to be telling somebody who's answerable to the stockholders what they're supposed to do. One of the things that concerns me is on December the 5th, Bank of America stockholders approved that sale or that purchase and that merger when they thought it was a $9 billion loss. And then the 14th, they found out it wasn't $9 billion, but $12 billion. And then because they decided that they didn't want to do that, they contacted you and Mr. Paulson. And whether Mr. Paulson said directly you told him to do it or not to do it, but the inference was there that the Fed said if they pull out of this deal, you know, their board and the CEO is going to be gone. Mr. Lackey said on the 20th, 2 days before they made the decision to go ahead with it, he said, just had a long talk with Ben, says they think that the MAC threat is irrelevant because it's not credible, also intends to make it even more clear that if they play this card and then need assistance, the management is gone. So even though they were going to incur $3 billion more in liabilities, because of the pressure put on by you and Mr. Paulson, they went ahead with that deal because they thought they and their management was going to be fired. And now that's the problem I have. The government is coming in and saying, you're going to do this or else. This is not a socialistic society. This is a government of free enterprise and of the people and by the people and for the people. And what bothers me is they thought they were incurring $9 billion. They found out it was $12 billion. And you told them, you and Mr. Paulson told them, you're going to do this or else. And I just think that's wrong. You can make a response if you like.
My response, sir, is I never said that to Mr. Lewis.
You never said this to Mr. Lacker's wrong?
Mr.
what he
Lacker,
said?
who was an internal person at the Fed, and again, those are his words summarizing a much longer discussion, said a more subtle thing than what you're saying. What he said was that if they took this decision and if they were required to be rescued, that if this decision led the markets to attack Bank of America and create a destabilization of the company, and the government had to come in on Sunday night and save them, that we would take that into account in thinking about management. That's a very different thing. And also, I did not say that to Mr. Lewis.
What about your attorney who said that you were going to put pressure on him? I brought that up in my previous 5 minutes.
Well, again, I did say very strongly.
I mean, he works for you.
I said to Mr. Lewis that that we strongly believe that invoking the MAC was bad not only for the financial system but for Bank of America, but I didn't tie it directly to replacing him or the board.
You have 5 minutes to the gentleman from Ohio, Mr. Kucinich.
I thank the gentleman. Chairman Bernanke, your staff believed that Bank of America knew about Merrill Lynch's accelerating losses in mid-November, a full month before coming to you and weeks before its shareholders voted to approve the merger. Those fourth quarter losses rose to over $15 billion out of the pockets of Bank of America's shareholders. But I want to ask you, did the Fed know about those accelerating losses before the Fed approved the merger at the end of November?
No, I don't think we did.
Well, may I introduce into evidence this email, which is from Dennis Herbst of the New York Fed to Audrey Overby of Merrill Lynch, and it's dated Wednesday, September 17th. It says, "Hope this gets to you. Audrey, our management, that is the New York Fed, has asked to continue the flash report on a daily basis, and I'm sure you'll share with the SEC." So the Fed was receiving detailed information by which they could have concluded that the overwhelming losses at Merrill Lynch were more than problematic, and that the Fed could have done something if they chose to. Now, are you familiar with this email, or are you saying that there's no?
Well, we are certainly involved in a light way in the oversight of those of Merrill Lynch since we began to lend to them, but we are not their formal supervisor, and our information about their losses would certainly be not.
But Mr. Chairman, the Fed knew what Bank of America knew. You were saying earlier, with respect to Bank of America, as a matter of fact, you really put on them the responsibility to notify the SEC. But yet, you knew before the merger was approved.
In September, I mean in November? We didn't know about the $14 billion. I'm sure we didn't know that.
But you knew about Merrill Lynch's condition before you approved the merger. Now, did you not? Did you not know about their financial condition was failing before you approved the merger? If not, if you say no again, that flies in the face of this email that came from somebody at the New York Fed who's tracking Merrill Lynch on a daily basis.
Well, they're tracking it, but it's difficult to know what these valuations are. They have to be done by professional asset managers. I was not aware. All I can say is I was not aware, and I don't think anyone else at the Fed was aware of the $14 billion in losses.
There's another email here saying that the Fed has followed up with the request for daily P&L, profit and loss, relative to Merrill Lynch. Now, and Mr. Chairman, I'm going to enter that into the record as well.
Without objection.
When you permitted the merger of this company that was too big to fail, you knew the company would be a significant player in 4 of the 5 critical financial markets: namely wholesale payments, foreign exchange, U.S. government and agency securities, and corporate and municipal securities. Isn't it true that the combined entity of Bank of America and Merrill, as a significant player in 4 of 5 critical financial markets, was a key rationalization for Fed action to bail out the merger?
I don't know. I'd have to get back to you on that.
Excuse me?
I'd have to get back to you on that. I don't recall the details.
Well, I'm going to read a quote from a Fed memorandum entitled Considerations Regarding Invoking the Systemic Risk Exception for Bank of America Corporation. And the quote is, "An inability of these organizations to fulfill their obligations in these markets and related systems would lead to widespread disruptions in payment and settlement systems in the U.S. as well as abroad." Now, in our investigation,